stopped at section 16 from section 15 of the Matrimonial Causes Act. I think we have been able to clearly establish the circumstances under which, or the grounds for dissolution of marriage. And then section 16 talked about specifically the grounds relating to section 15 sub 2c, which is
Section 15.
section 16 specifically talked about section 15 sub 2c, which was that since the marriage the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with the respondent. So today we're taking up from section 17. So we'll continue the way we ended yesterday. And section 17 is additional provisions to encourage reconciliation. Sub 1 says where the petitioner alleges that the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with him, but the parties to the marriage has lived with each other for a period of periods after the date of the occurrence of the final incident relied on by the petitioner and held by the court to support his allegation. The fact shall be disregarded in determining for the purpose of section 15 sub 2c of this act whether the petitioner cannot reasonably be expected to live with the respondent if the length of that period of those periods together was 6 months or less. I repeat, and I know we're all checking our own, where the petitioner alleges that the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with him, but the parties to the marriage have lived with each other for a period of periods after the date of the occurrence of the final incident relied on by the petitioner and held by the court to support his allegation. That fact shall be disregarded in determining for the purposes of section 15 sub 2c of this act whether the petitioner cannot reasonably be expected to live with the respondent if the length of that period or of those periods together was 6 months or less. Who got that? Yes, Jeremiah.
Uh, from my understanding, it has to do with where one of the parties is claiming that the other party has behaved in such a way that he cannot reasonably be expected to continue in the marriage. However, on the date he has alleged that thing has happened, from that date, they have lived together for a particular period. That if that period is 6 months or less, that period will not be considered while trying to determine whether or not they can still, like trying to determine whether they can still live together or not.
Okay, the period of 6 months.
Yes, or less.
It will not be considered. Is that the implication? That it will not be considered? That is, you are saying that
That fact will not be. Yes, that's what I understand.
any other person, or is that the final position? I was getting a different understanding. It says that fact shall be disregarded. The fact that it's trying to disregard, it says where the petitioner alleges that the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live. But the parties to the marriage have lived with each other for a period or periods after the date of the occurrence of the incident relied on by the petitioner and held by the court. That fact shall be disregarded. Examine whether the petitioner cannot reasonably be expected to live if the length of that period or those periods together. Okay.
My understanding is that this section 17 now is now talking about section 15 to C, which is if the respondent has behaved in a way that the petitioner is not expected to live with him reasonably. So now this section is saying that if that period, because that particular section now, 15 to C does not even state any specific act but said reasonably. So if the allegation in this section 15 sub 2c is less than a period of 6 months, it will be disregarded.
Amen. I was trying to confirm what fact it said was that fact. So I'm seeing that the preceding paragraph before where it says that fact shall be disregarded, the preceding phrase there is that the parties to the marriage have lived with each other for a period or periods after the date of the occurrence of the final incident relied on by the petitioner. So the fact that they have lived together for a period after the incident, there's an incident the petitioner is relying on for her ground of divorce that they cannot reasonably live together. So if after that incident they still live together, the fact that they live together will not undermine, in fact the court will not consider the fact that they live together at all to affect the allegation of the petitioner. So irrespective of the fact that they live together, if the allegation is that for a particular incident I cannot reasonably stay with this person, the court will still accept it and disregard whether or not they live together, so far as that period they live together is not more than 6 months. Meaning if the period they live together is more than 6 months,
They
the
will
court
consider
can
it.
use that fact to say that means
No, you
it's
can
not
stay.
so unreasonable.
Mm.
Because if it was so unreasonable, you should not
should
have
have
stayed up to
more than
beyond
6
6
months.
months.
So if they beat you today and you, by reason of that beating, you are giving that as your reason why you want to leave the marriage, for example. And then after that said beating that even got you to the hospital, you have stayed with the man for 6 months, for a period of 6 months. It's immaterial. It's immaterial. You understand? But when it's above that 6 months,
That is less or 6 months is immaterial.
yes.
Yeah.
But once it's above that 6 months, then the court can now reconsider that, okay, that means maybe this thing can work since you people have now been together for over 1 year.
I
And
don't
you
know.
have
Is it
not
that
been
the court?
beaten
Is
again.
it that the court will consider or that the information can be useful?
Okay, the court.
One says it will
but
be
once it
disregarded.
is,
In one circumstance, I think that fact is useless in the proceeding.
yes.
But in another circumstance, the fact can be
Mm.
useful
But once a fact is useful, then it is considered by the
by
court.
the
It's
court.
the same thing.
Okay.
That is my.
Any other position? So two, in considering for the purpose of section 15 sub 2 of this act, whether the period for which the respondent has deserted the petitioner or the period for which the parties to a marriage have lived apart has been continuous, no account shall be taken of any one period not exceeding 6 months, or of any two or more periods exceeding 6 months in all, during which the parties resumed living with each other. But no periods during which the parties lived with each other shall count as part of the period of dissertation or of the period for which the parties to the marriage lived apart, as the case may be. I repeat, in considering for the purpose of section 15 sub 2 of this act, whether the period for which the respondent has deserted the petitioner, that's deserting is under section 15 sub 2, no, 2d, talks about deserted. So in considering for the purpose of section 15 sub 2 of this act, whether the period for which the respondent has deserted the petitioner or the period for which the parties to the marriage have lived apart, okay, not just even living apart for 1 or 2 years, has been continuous. So in checking that continuous time, no account shall be taken of any one period
Not exceeding
not exceeding
6 months.
6 months, or of any two or more periods not exceeding 6 months in all, during which the parties resumed living with each other. But no period during which the parties lived with each other shall count as part of the period of dissertation,
It is action.
of desertion, or the period for which the parties to the marriage lived apart, as the case may be. But who got the point?
It refers to the continuous how the counting of the time frame
Yes,
should
because
be.
yes.
Should be if you say a continuous period.
Mm,
You understand? Then you say you left in 3 months, then you came back.
mm,
You understand? Before you now left for another 4 months, then you want to add that 4 months to 3 months as though it's a continuous period. It doesn't work.
But
I think
beyond that,
that's what they're
what
trying
is
to
also
say.
saying is, I think it's two-sided. One, section 2D says a period of 1 year desertion. It does, I think section 15(2)(e) talks about 2 years living apart, where the respondent do not object to the
Application for the
for
solution.
dissolution. While section 2 sub 2F talks about a period of 3 years with or without consent to dissolve. So where you are now counting that 1 year, or counting the 2 years, or counting the 3 years, as the case may be, as a ground for divorce, is saying that peradventure the parties now came together for a period. You are counting dissertation as maybe from last year July to this year July, but now these people now stay together for maybe 2 months,
Yes.
3 months. It says so far as it does not exceed 3 months, 6 months, it will not affect the counting.
Okay.
However, you will not count that period in
As
it.
part of the 1 year.
So you can count if they stay together from December to January, and you are counting from July. It means you now count July, August, September, October, November. You will pause. You will not count December and January. You now start from February. You not start afresh. You start afresh. That's the thing. You now
No,
start.
you not start from February.
Yes, but you are continuing.
Yes,
So this was 5 months, but you jump December, jump January. From February, you now start 6 January, February, March, April, May, June. This is now 12 months. June, July, 12 months. So ordinarily, it should have been shorter to get 1 year, but now 12 months becomes longer because of that 2 months that they stay together. But you will not count the 2 months.
Yeah.
Also, the 2 months will not deny you the counting by saying because you have stayed together 2 months, the 1 year counting should start again.
Okay.
I don't know if I'm on track.
Yeah.
That's what you got, Tracy.
Yes.
Three, references in this section to the parties to a marriage living with each other shall be construed as references to their living with each other in the same household. That's clear.
Yeah.
So when we talk about living together, it's in the same household. So living together in a place that is not their household, maybe they traveled somewhere.
It's the same household now.
So far as they are in the same place, I mean, together.
At best, in our own local interpretation, will be under same roof.
Okay.
So, in a situation whereby there is flood, for example,
Mm.
like this our region in Bayelsa that we have flood issues. So, will you now say because they are living in a hotel temporarily because they were affected by flood, or they went to live with one of their uncle who has a duplex somewhere? You understand? And they needed to stay there for about 2 months. They are still together. It's a household. It's the same household.